can send us a document.
This one?
Yes.
Word
I
doc?
have one coming.
But that requires like going to Google, and I gotta figure that out.
All right, we're going to go ahead and call the September 12th, 2022 Apex Planning Board meeting to order. Please bow your heads for the invocation. Father God, thank you for another day and the opportunity to serve the town of Apex. Give us wisdom and discernment as we hear the cases brought before the town today and make the best decisions for the town. In your name, Jesus, we pray. Amen.
Amen.
Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Do we have any items of information, Diane?
Yes, I wanted to remind everyone that I had sent training that the School of Government is offering, and several of you have responded, and I appreciate that. Whether you're able to attend or not, if you could please email me today, like you can go ahead and email right from this laptop if you want, or when you get home, because I do need to sign up the folks who choose the September 29th date by tomorrow. The October 6th date, I can wait till end of next week to do that. We'd like for everyone to attend one session if at all possible. I know a couple folks have attended in the past and have told us it's very valuable, and so we would like for everyone to sign up for one of those dates if possible. And then the other thing is the dissent forms somehow got taken off your laptops. They were supposed to stay there from last month, so Amanda is emailing them to your town email address right now. So if you need the electronic copy, otherwise you can always use the paper copy that's been passed out. And that's it for today.
Thank you. All right, so public comment. The purpose of public comment is to allow the public to speak on items that do not appear on the agenda under the public hearings. Any member of the public wishing to comment on public hearing items will be called at the appropriate time later in the agenda. If you have not done so already, please sign here on my right, your left. Sign in under the appropriate agenda item. Comments from the public on new business will not be taken later in the agenda, so if you wish to speak on new business items, public comment is the time to do so. All comments are limited to 3 minutes. When the 3 minutes is up, the speaker will ask that the chair to wrap up their comments. If there are a large number of speakers for a particular item, the chair will ask that a representative select and speak for the entire group and limit the comments to 9 minutes. If not, comments on a single topic should not be repetitive in nature. If comments were already made by another speaker, simply state you agree with the prior speaker's comments. All right. On to consent item number 1, minutes from the August 8th, 2022 regular meeting. I take it everybody has read those minutes. Any changes or omissions? Do I have a possible motion to approve the meeting minutes from the August 8th?
I'll make a motion to approve the meeting minutes as currently drafted.
All right, Mr. Akers has a motion. Do I have a second?
A second.
All right, thank you, Steve Rhodes. All in favor, say aye.
Aye.
Any opposing? Passes unanimously. Thank you. All right, we will now move on to the public hearing section of the meeting. Item number 1, Jenna, you're going to talk to us about some amendments to the bicycle and pedestrian plan.
Yes, sir. Good afternoon.
Afternoon.
So I'll be presenting for public hearing number 1 regarding an amendment to the bicycle and pedestrian system plan map. So for this amendment, we're looking at Lower Duncan Road, shown right here between Old Apex Road and the Apex Cary boundary, where it goes from light green to gray. And the proposed amendment is to add proposed bicycle lanes along this section of Lower Duncan Road. And this This coincides with the town of Cary's plans to stripe bike lanes along their section of Lower Duncan Road. And there's an existing bike lane in Apex along the east side of Lower Duncan Road, south of Old Apex Road. So this would continue the bike lane north. And once the bicycle network is built out, there will be bicycle lanes along Lower Duncan Road, as well as a section of North Salem Street and Salem Church Road. And there's an existing street side greenway that was built more like a side path along the east side of Lower Duncan Road in the town of Cary's jurisdiction. And then the plan is to keep the proposed side path along the east side of Lower Duncan Road in Apex, shown with this purple dash line. And this is being brought forward today because the town was made aware of this project in July of 2022, following the proposed rezoning for the North Salem Station PUD in May. And then on August 29th, the project planner for the North Salem Station PUD reached out to residents who had contacted the planning department regarding this rezoning to let them know about the proposed amendment to the bike ped map. And then town staff also plan to coordinate with the developers of the North Salem Station PUD to stripe these bike lanes as part of their project. And I'm here to answer any questions that you may have.
Any questions for Jenna?
Does the addition of the bike lanes increase the right-of-way width, or are you just proposing within the curb-to-curb dimension, just restriping?
So the town of Cary's is just to restripe, and our traffic engineer is gonna be working with that developer. So I don't know exactly yet, so he's working on the limits to figure out how exactly that's gonna work within our section of the bike lanes.
Recall during the South Salem, or the North Salem Station PUD, the traffic through there was a concern with people speeding, so less pavement, closer proximity. I think the buildings are pretty tall through there as the mixed use. I think that came up, that they wanted to slow people down, so I didn't know if that was a consideration.
Slow people down with the bike lanes. I think that's been found when there's a bike lane, people tend to.
They're not going
slow
wider
down.
lanes, but like just using the existing narrower street section.
Yeah, that's what I imagine will happen, since that's what's happening in Cary, and it's a similar cross-section when you get into Apex. But the details of that will be worked out with the development.
Is signage included in this too?
Bike lane,
What Ryan was talking about.
for the bike lanes, we normally have, it'll be, where exactly the signs will be, or it's normally pavement markings with the bicycle symbol and an arrow, but those details haven't been worked out yet.
No vertical signage. I think this is currently where, isn't Laura Duncan Road, it's currently under construction? They're widening it, is it that area?
Lake Pine, they recently did a restriping project along here to add that bike lane, but Lake Pine may be the one you're thinking of with the current construction.
Yeah. Thank you.
Sure.
Any other questions for Jenna or a possible motion?
I'd like to make a motion to approve the proposed bicycle lanes along Lower Duncan Road, what was presented.
Motion from Sarah
Second,
and a second from Tina, is that right?
yes.
All right, thank you. All in favor, say aye.
Aye.
Any opposing? All right, passes unanimously, thank you. Item number 2, Sarah is going to talk to us about a possible motion regarding the rezoning case 21 CZ 17, 1010 Business Park.
Thank you, Mr. Chair. Good evening, Mr. Chair, members, board. Thank you. I'm going to be presenting public hearing number 2, rezoning case number 21CZ17 for 1010 Business Park. So we're looking at subject site over here in the general southeast area of Apex, south of US 1. I'll zoom us in here a little closer to the site. So this is a portion of this parcel that we are looking to rezone. Or that the applicant rather is looking to rezone here. It is this boundary here, located off of 1010 Road. It is approximately 4.6 acres. As you can see, the subject property is vacant and wooded, and something that will come into play just a little bit later but just so that you know, there is an existing communication tower on the portion of the site that is not included in the rezoning. I'll explain to you a little bit here when that comes into play. So the subject site is currently zoned residential agricultural. The proposed zoning is light industrial commercial zoning. The 2045 land use map has identifies the subject property as industrial employment, and therefore the proposed rezoning to light industrial conditional zoning is consistent with that land use classification. So I'm going to bring us back here into this site. So again, just to orient you a little bit more, we have self-storage over here. There's a colonial gas facility over here to the right, and then as I mentioned, over here is down here is the tower. So the applicant conducted a neighborhood meeting on April 28th, 2021. That meeting report is attached in your documents. Given the time span since the applicant submitted last summer, they have gone ahead and held another neighborhood meeting that was held last week, and that packet was presented to you today on your seats there. So that is also included. There is a full listing of permitted uses consistent with the LI district in your staff report. So you'll find that on pretty much all of page 2 and a little bit of page 3 of your staff report. The applicant has added a few zoning conditions, and that is where the cell tower information is going to come into play. So the first condition is that the developer is proposing a 12-foot type C buffer along the eastern and westernmost boundaries of the area to be rezoned, with the additional condition that the planting of such buffers will include a minimum of 3 species of native hardwood canopy trees with a size at installation no smaller than 2.5-inch caliper. The buffer shall not preclude vehicular cross connections to adjacent properties pursuant to an approved site plan, nor shall it apply to a publicly dedicated street right-of-way pursuant to a duly approved subdivision plan. Number 2, tower improvements substantially similar to or greater than those that serve as the basis for the zero fall zone letter submitted with the rezoning application shall be constructed, and a certification of the completion of construction of such improvements shall be submitted to the town prior to approval of construction drawings. And number 3, for any building greater than 10,000 square feet, the building design shall include conduit for the future installation of solar PV panels and sufficient roof load-bearing capacity to support solar PV panels. And during the petition review, staff had recommended to the applicant to limit the use self-storage to self-service storage access only, just because we're looking at only a portion of the site and not the entire site. So staff had made that recommendation, given the property's location on 1010 Road. Planning staff recommends approval of 21 CZ 17 1010 Business Park with the additional use limitation and conditions as offered by the applicant. Approval of the rezoning is reasonable because the proposed light industrial conditional zoning district is consistent with the industrial employment land use classification on the 2045 land use map. The proposed rezoning is reasonable and in the public interest because it will allow for the development of non-residential uses that are consistent with surrounding properties, especially those on the south side of 1010 Road. It will also encourage compatible development of the property and increase the tax base. I'll be happy to answer any questions for you at this time, and the applicant is here as well. Thank you.
Any questions for Sarah? Did the applicant want to speak?
Very briefly, I hope extensive comments won't be necessary after such a great staff report by Ms. Van Avery, so I appreciate her extensive report. Let me just introduce the folks that are here with me. The applicant is J National Capital 4 LLC. His manager member is Mr. Bill Jackson, who's here with me. Next to him is my colleague, Aaron Catlett, and Ms. Amy Clayman is Mr. Jackson's colleague as well. So we're here to answer any questions that you might have and appreciate the opportunity to make a brief presentation today.
Your name again?
Thank you. I didn't introduce myself. Gray Stiers. I'm an attorney at Fox Rothschild, 434 South Fayetteville Street, Raleigh, North Carolina, 27601. It's been a long time since I've been before this board, so it's good to be back here today. Thank you very much. Again, Ms. Van Avery did a good job hitting the high spots, and sometimes I'm before boards on zoning cases in which there's a lot of controversy. I'm sometimes asking for a change in the land use plan. Sometimes I have a lot of opposition. So it's nice to be here before you today in which I don't have any of those circumstances before me. Again, this is the G105 FM tower that is off of 1010 Road, as you know. It is an oddly split zone parcel. I don't know the history of the split zoning. I don't know if perhaps there was an old house that may have been fronting 1010 when the town initially did its rezoning. Why it got zoned with RA inconsistent with your land use plan is a mystery, but not a necessary point for the decision today. But it's a remnant. It's a split zone remnant, and we're just trying to bring the zoning classification into conformity with your land use plan. You know, all of you are very familiar with your 2045 land use plan map, I know, and if you look at the very back appendix, you'll see what are the land use zoning district classifications for the industrial employment use, and RA isn't one. It's not an appropriate classification. So we find ourselves today basically cleaning up this remnant of RA zoning that is there. Making it consistent with your land use plan and with the added benefit of strengthening the tower that has been there now since the early 1980s. Over the subsequent 40 years, technology has improved, standards have improved. There's been hesitancy, I think, by some to develop the land around that tower, knowing that it's an older and very tall tower. And so it was identified specifically as a parcel in your 2045 plan as an underdeveloped parcel, not contributing to its potential to the town's tax base. So, and in discussions with staff over the past year, staff said, we really want you to bring that tower up to current standards and with a zero fall zone letter. And Mr. Jackson and his company have agreed that as a condition of the rezoning and the development of the parcel consistent with the light industrial classification, he will, if this rezoning is passed prior to site plan approval, as set forth in our conditions, bring that tower up to current standards and strengthen it. The analysis has been done by an engineering firm by the name of Stainless, and this is what they do for towers. And the plans we have submitted to staff, and the staff has reviewed those. And then we have the opinion letter from the engineering firm, which says Engineered Tower Solutions, saying once those improvements are made, then it will be up to standards and will in essence have a zero fall zone in the event of a catastrophic weather event. So, you know, in many respects, this is a win-win-win for the town. It opens this parcel up for development. It no longer will be underdeveloped. It'll be able to contribute to the town's tax base. The tower will be strengthened and brought up to current standards, and a odd remnant of an inappropriate RA zoning portion will be brought into conformity with your land use plan as light industrial. Again, as Ms. Van Avery said, we have had 2 community meetings. There is no opposition. We had people at both who came and said, I'm curious, and we answered their questions. They said, thank you. It's good to know what you're doing. And it was, again, very cordial and a pleasant community meeting, which is always nice to have as well. We did work with staff on the language of the rezoning, so glad we could come to you today with language that the staff can support, and very much appreciate their recommendation of approval of this rezoning. So we're here to answer any questions that you might have, but that's, in a nutshell, you know, they say a picture's worth 1,000 words, and when you have this picture here that's up on your screen, and then that picture is being proposed, and that picture is the land use map, that pretty much it says it more eloquently than anything I could do here at the podium. So I'm glad to answer any questions that you might have at this time, but that concludes my remarks.
Thank you, Mr. Dars. Any questions for the applicant?
I do. I have a question about the zero fall zone. Is that, if the engineering firm, is that, so they design it so it doesn't fall and you have to take up the land for the whole tower? So is that?
Exactly, it would collapse on itself, in
Okay.
essence. Yes. So in the event, so basically, it does not create a risk for around. Now, if there's a tornado, if there's an inch of circumference, inch radius of ice, then all bets are off for all of us, but no one's going to be out there anyway. But in essence, in those types of catastrophic events, it would basically have designated points within the tower structure that it would collapse on itself and not create a risk for anyone.
Eliminating the radius of the tower?
Exactly,
Okay.
exactly.
Thank you.
To build on that a little bit, first of all, I didn't know that was a G105 tower, so thank you for educating me there. Wondering what are the parameters of which, you said if there were a catastrophic event, what is the catastrophic event? What are those definitions?
Yeah, generally, and I'm not an engineer. I did stay at a Holiday Inn Express last night in another town before driving in here, but I'm not an engineer. But generally, the design of the tower looks for 1 inch radial ice up to that standard. So think of not a half inch or a quarter inch, but 1 inch radial ice. The guide wires are intended to support the tower with up to 1 inch of radial ice and usually a 30-mile-an-hour wind. So you have to have both the ice and the wind
Okay.
is typically where you might find that type of event. It's a building code standard by the building code, such as this building that we're standing in
Right.
is designed, or your home is designed to withstand certain weather events. For this building and weather events, you're going to, you think about tornado. And actually, in events of a tornado, there's actually very little flat surface to a tower like this. There's very little wind resistance. You always get the risk of debris being blown into a tower, which is beyond anyone's control. But it's usually a radius of ice and wind combined that could result in a tower this tall, and I actually have the stats here in front of me. The further you go up, the colder the air temperature is, which is another reason you get the zero fall zone. The tower is actually, I think, about 1,500 feet high. So the formation of ice is also going to be higher on the tower, which is the reason that a collapse occurs at the top and not at the bottom.
Oddly enough, I know more about this than I should. My dad's a ham radio operator, so we have a tower outside of their house, so I actually
I hope
know
what
this.
I hope what I said made sense.
But, and so the reason why I was asking about the catastrophic was I wanted to understand that it is in current building code. It is not, if we had a category 4 category, it is within our current zone.
That's correct.
Thank you so much.
The current tower currently, I don't think is up to current code.
Right.
That's what we're trying to bring it up to if this rezoning were approved.
Thank you. Also appreciate that you have our land use map. Thank you.
Do you know how high the existing tower is right now?
Okay, so I do. I have a lot of papers here in front of me, but let me just give me one. Here we go. The current tower is exactly 1,576 feet high, above ground elevation, according to the FCC and FAA.
So the new proposed will be lower, shorter than this?
No, we're not changing the tower.
Okay.
No, we're not changing the tower whatsoever. It's, the tower is a framework lattice of metal connections. And as set forth in the plans, it's been an analysis of where the lattice gets strengthened so that it will come up to current standards. And if it were to collapse, fail, it would have a zero fall zone because it would collapse on itself, in essence. So we're proposing no change to the tower. The tower and the land is currently owned by a company called Vertical Bridge. They have an arrangement for G105 to use it. And then if this rezoning were to go through, they would still maintain the tower exactly like it is today. It's just that with the strengthening of the tower, Staff is comfortable, and at this point, we could then develop around the tower with the strengthening that's occurring.
So, basically reinforced,
Excuse me?
reinforcement.
Yes, that's exactly right. Thank you. Looking for the right verb late here on a Monday afternoon.
And then another question I have is, there was a mention about the buffer along the east and the west. Is there anything on the south? on
No,
the
because
side?
that's one contiguous parcel. That is just the split zone boundary. So it's not a separate parcel. So everything, the rezoning only pertains to the 4.6 acres. And it's the same parcel, same ownership. Mr. Jackson will own the entire area.
Puzzle piece.
That's right. That's exactly right.
Thank you.
Thank you.
Any additional questions?
Thank you for your time, and again, happy to answer any questions that you might have.
Thank you.
Thank you.
So, open up the public comment section. Do we have anybody who wants to speak? All right. Then we'll close that and bring it back to the board for further discussion and possible motion.
I'm excited that that this proposal's come before us. I'm excited about expanding our tax base, and bringing it in alignment with the 2045 land use map. So, unless anybody has anything to add or discussion, then I'll make a recommendation to approve rezoning case 21CZ17 as presented, at 1010 Business Park.
So I have a motion from Ms. Sherman. Do I have a second?
I can second.
And a second from Ms. O. All right. All in favor, say aye.
Aye.
Any opposition? Passes unanimously. All right, item 3. Sarah's going to talk to us about a public hearing and possible motion regarding case 22CZ13, the 2021 North Salem Street PUD.
So one point of clarification, if I may,
Yes.
with respect to that last case. That tower is designed not only for a 1-inch ice accumulation, but not a 30-mile-an-hour wind, but a 130-mile-an-hour wind.
Oh, wow.
That sounds catastrophic.
Yeah,
That's,
yeah,
Very
so,
different.
so,
Thank you.
so you've got to exceed all that, and it still has got safeguards built into it.
Got it.
So you could have that ice accumulation and get hit by a hurricane, it would still stand under the new standards. Just so you guys know.
Fantastic.
Thank you.
Yes, we think we've really done it right.
I think you did a great job.
yes, thank you so much.
Wasn't an engineer.
No worries.
All right, Sarah, let's talk about case 22CZ13.
Let's talk briefly. Mr. Chair. So this item is going to be renoticed at a later date. The applicant is still working through some things, as if you'll remember. Default before it's being continued, so we will renotice completely. That means new planning board notices will go out again, and then obviously subsequent town council notices. So there will be, when we have a date set, we will be renoticing with that date. So I don't have any information to present to you this evening.
Sarah, will there be additional neighborhood meetings, given the time lapse? I don't know if we're outside of that.
This one was submitted earlier this year. Whereas that one came to us, I believe, July of last year.
Right. Understood.
And then they had spent the time working on the fall zone study since then, but this one is, I think, still tracking on time and
Okay.
won't require that.
Thank you.
Sure.
Thank you. All right, on to item 4. Lauren is going to tell us about the public hearing and possible motion regarding rezoning case 22CZ16, 1039 Iron Gate Drive.
All right, good afternoon, everyone. This is rezoning case 22CZ16 for 1039 Iron Gate Drive. I would like to point out that the intent of this rezoning is to fix the front setback. So as we move forward, you'll see more information on that. The property is located inside of our corporate limits in this general area. The subject property is a total of 0.46 acres and is located on the south side of Iron Gate Drive and east of Tingen Road. the property contains an existing foundation for a single-family dwelling that does not meet the setbacks of the current zoning district. The dwelling has already been moved to the site, but is not yet on the permanent foundation. The foundation was poured without receiving building permits. A building permit was submitted in March, but not approved. The rear of the site is vegetated as well. The property is currently zoned rural residential, and all the adjacent zoning districts are also rural residential. The applicant is proposing to rezone the property to medium-density conditional zoning. The 2045 land use map identifies the subject property as medium-high density residential office and employment. The proposed rezoning to medium-density conditional zoning is not consistent with the land use classification. If the property is rezoned as proposed, the 2045 land use map will automatically be amended to medium-density residential. The applicant conducted a neighborhood meeting on June 23rd, and a copy of the neighborhood report is in your packet. A full list of the proposed uses and zoning conditions can be found on page 2 of the staff report. The applicant is proposing single-family and accessory apartment. The 3 proposed zoning conditions include: the minimum lot width shall be 90 feet. Number 2, the front setback shall be at least 25.5 feet. And number 3, no permitted encroachments within the required front setback shall be allowed, with the exception of eaves. As mentioned, with the intent of the rezoning, that is to fix the front setback, planning staff suggested the zoning conditions to address the concerns while keeping the property as consistent with the surrounding properties as possible. This rezoning was exempt from meeting with the EAB per UDO section 2.19A2. The proposed rezoning is under 1 acre and is proposed to resolve a nonconformity. A letter of impact from Wake County Public School Systems was not requested for this rezoning, as an increase in the number of homes shall not be possible based on the proposed zoning conditions. The proposed rezoning is reasonable and in the public interest because it resolves the nonconformity associated with the current placement of the foundation for the single-family dwelling. The existing foundation was poured in the front setback of the current zoning district, causing a compliance issue with UDO section 5.1.1, Table of Intensity and Dimensional Standards, residential districts. The proposed rezoning conditions also ensure that the lot cannot be further subdivided so that it remains consistent with the lot sizes in the neighborhood. Planning staff can recommend approval with conditions as offered by the applicant. I'm happy to answer questions, as well as our applicant who's in the audience.
Any questions for Lauren?
So basically, we're just fixing a nonconformity at this point?
Yes, sir.
Okay. Pretty clear. Thank you.
Yes, sir. Thank you.
The applicant want to speak?
Excuse me, what did you say, sir? I couldn't hear you.
Asked if the,
No,
Oh.
you can't, I'm sorry.
I'm sorry. I asked that, we're just basically trying to fix a nonconformity, and she said yes. No, thank you.
Thank you, sir.
You're welcome.
How y'all doing? I'm Aaron Robertson. I own the property. A little bit about the situation. I hired a contractor. I moved the house from another location down the road, Verita Parkway, Carolina Springs, because they're doing the development. And by doing so, he filed for a permit, got rejected. Sonia with ECLS, they were doing my surveying of the lot and staking the property and whatnot. And I guess the contractor, Paul Satterwhite, who was working with them, she can tell you her situation with them as well. Pretty much, it was off a few feet, I think 15 feet roughly, something like that, and had already moved the house. And we had a third party do our foundation and everything because Paul said it might not be available, or the permit might not be back, because he said it was like 5 to 10 days. And I was under the impression we had the permit, so we went ahead and did everything. And then about 3 days later, they put a no work sign on the thing, and he's been MIA. I'm taking that into taking him to court, doing that on the legal side of things, and he's no longer with me. So pretty much I'm here now to try to get my family back into our house. I didn't think it'd take this long. I brought them with me, but my wife and the youngest one, I think he was getting a little out of hand, so he walked outside, so he wouldn't disturb us. But basically just asking for, 15 feet so we can keep the house there, and then follow suit with what goes on, permits and all rules and regulations. That's why I'm involved with it now, because Paul's not handling anything for me. I've learned that I can just do it myself. I didn't know that you had to have a GC license, or you could just do it yourself if it's your house. So that's what I'm doing now, trying to take it upon myself. That way I know everything can go smoothly and whatnot. So you want to add anything, Sonia?
Yeah, I can. I mean, I just wanted Sonny Ward, surveyor with DCLS Global. We did the plot plan and everything for him to take care of this.
What's your name, ma'am?
Sonia Ward.
Sonia Ward?
And I just wanted to make sure that it was known that basically, I think the biggest issue is trying to get this setback. It's a small portion of the front right of the house that actually protrudes. The front porch, none of that, the steps, none of that would be coming into the setback at all. And that I think the biggest issue during the neighborhood meeting was basically drainage, because it's sitting, they put a stop work order, so he's not able to fix the drainage. So every time it rains, it affects the neighborhood. So I think that was the biggest issue with them. But yeah, that was pretty much it. Any? Okay.
Ma'am, can I have you sign in, please?
Yes, I'm sorry.
Any questions?
I actually have more of just semantics questions for Lauren. So these are currently zoned in the town of Apex, or are they county and he's looking to zone into Apex?
They are currently annexed into the town.
They are. Why would we rezone in such a case? Why couldn't he just do a Board of Adjustment variance?
It doesn't meet the hardship. That was,
Self-created.
unfortunately, even if
Well,
it,
you didn't self-create it, but.
but
Yeah,
through, right.
I'm having penalized for it. Obviously, it's my house, but so I'm just having to deal with it.
Right.
Mhm.
Yes.
Thank you.
Thank you.
That was a good question.
Yes, thank you. Thank you, sir.
Thank you.
Thank you, guys.
All right. So I'll open up the public comment section. Do we have anybody from the public that wants to speak? Step up, ma'am. State your name
My
for the
name
record,
is
please.
Norma Stewart Winston, and we were looking so forward to have Aaron in our neighborhood. He started on the prep of his property for some time, and then on Sunday, his house was moved in, and on Tuesday, they start underpinning this house. A few weeks later, everything stopped. So then I was confused about what had happened. So he came around a bit later telling our neighbors that the property didn't have the proper setback, and to get a permission slip from residents. So my question, I did sign the permission slip, but then after I thought about it, my question was, how does this work? Is it okay for a permission slip to be signed without the permit? So I came downtown, and when I did, I was told they had not received a permit. I don't know exactly what this rezoning would mean to me. I live directly across the street from where this house is. And when the engineer and the engineers and the contractor came in to tell us, speak with the members, the neighbors, to tell us what happened, she said that when she drew the plan, she drew it backwards. So it was not supposed to sit that way. So I don't understand what effect would this have to the neighborhood. I've been in this property for 40 years now, and I like to know what effect this is gonna have for me coming out of my driveway, running directly into his house. When I first saw, when they moved that house in, you could just, it's like it was sitting right in the street. And I can understand, we're supposed to love our neighbors and take care of each other. However, people need to be responsible for what they do. My question is, what else can be done to rectify Aaron's problem than the neighborhood agreeing to rezone? Because I don't know what effect the rezoning will be to my property as well.
Lauren, can you address
Thank you.
that?
So the rezoning is for this property in particular. It
Yes, I
won't-
know it's for this property, but when you say rezoning, so if it's for this property and it's there and you can change it to rezone it, why does it have to be rezoned? Why can't he continue to build it where it is? So that's an issue that I have as well.
So this is the only way he can keep the house where it is currently. It will not affect any other properties in Iron Gate. It only affects his property to allow him to keep the house where it's sitting currently. If they turn down this rezoning, he will have to move that house.
Would that include the foundation? You would have to move the foundation?
Yes, he'd have to tear out the foundation and put in a new foundation and move the house to the proper setbacks.
And then can I add, or I guess ask, make sure, I'm gonna state this, and I wanna make sure I have it correctly. It will not move, and then that is because of the additional stipulations that are put in the rezoning, that is it. Is that a correct assessment? It does not affect, the house will sit where it is and will not affect any of the other homes in the neighborhood.
But my question is, why does it have to be rezoned? Why can't they just complete it? I mean,
It's unfortunately, it's the regulations of the town require that communities meet the certain standards that are set out. And so right now, because of the error of the previous contractor, it is falling outside of the standards. And so what Mr. Akers was asking is, there is a different way to address some of the issues, but unfortunately, that way was not available for this particular, it did not mean, I couldn't tell you why. The staff would be able to share a little bit more about why it didn't meet the hardship requirements that would allow it to not be rezoned, but because it falls outside of the current guidelines of the town, it would have to be rezoned to stay as it is and for work to continue and for him to be able to live in the home. Does that make sense?
it makes sense, however, it sounds like that you can do things that's out of the norm, that's improper, and you can just go back and get it rezoned to fix it because you didn't follow proper procedures. So who's being held accountable for what happened to his home?
That is an excellent question. I would venture to say, and I'm going to look to staff, that this is not a normal procedure. That is why this body exists, so that Mr. Robertson and yourself and the neighbors can come and share concerns, and we would take all that into consideration. Then again, it will go before town council, so we would make a recommendation, and then town council. This is incredibly out of the norm, and I think this is, I appreciate staff attempting to make it work within the current confines, but you're absolutely correct. This should not be the way it is, and I am so sorry that Mr. Robertson had an individual who he's unfortunately now going to be taking to court, who did him wrong. I don't know if does that help, and I invite staff to weigh in if I misspoke.
No, I appreciate you trying to help me.
Absolutely.
Thank you.
Hi, my name is Sharon Fuller Green. I am at 1037 Iron Gate Drive, which is next to Mr. Roberts. So when he first came, welcomed him in the whole 9 yards. My issue is that his house, my house, I'm getting the water off of his roof and from where it stopped from, because the completion of the house is not. So the water is coming in my yard near my sewer. I did talk to Mr. Roberts, and there's a swell that's on my land. He came in and he dug the swell a little bit deeper, and the water began to run the way that, I'm not going to say it originally ran, because trees were there. So the trees was absorbing the water, and it'll just be a little twinkle here, there, down the stream, down on the side of my house, and then the back of the house, and then the back to Joe Perkins, Sandra and Joe Perkins. So the issue now is because there was a stop order, getting rain from the roof, getting rain from the drain, and it's just so, I mean, I videoed everything, but you if you see the, I think the inspection people came out and looked, the environmental people came out and looked. So my thing is, okay, if it stays as is, what is going to be a barrier? Where is there going to be, what's going to stop, not all of the water, because nobody can stop any of the water because it comes from above. But what would be, if the house stays as is, then what would be your recommendation to Mr. Roberts that something be put? And what I'm really, really worried about is my sewer, because it's running all in my backyard. He did dig a swell on the right side of my house, which runs parallel to Sandra and Joe Perkins. So again, my concern is the runoff that has been from March all the way up to now, and it's crevices, and you know, he's did all that he could possibly do. He cannot step foot back on the property until a decision has been made. In the meantime, I'm getting the rain, and I do not want it to go up under my basement. Right.
Understood.
So that's mine. Thank you all so much. Any questions? Okay, all right.
Thank you.
Thank you.
Good evening.
Evening,
Good
sir.
evening.
It's a pleasure for me to come before you. I did not know that my town of Apex had a panel like this.
Welcome.
And I'm really, really impressed to see you.
Your name, sir?
My name is Joseph Perkins.
Mr. Perkins.
Okay. Now, I live down in Iron Gate, and I've been down there for 46 years. And the house, they were moved in there. There's several questions, and maybe somebody, you can answer the question for me. First of all, I'd like to know how he got a permit to put it in there, okay? I would just like to know how he got it, right? Because those are little half-acre lots, okay? And there is no septic, no sewer, no city sewer. So you gotta put in your own sewer, okay? And like I said, I've been in there for 46 years. I know exactly how all the water runs. I know every little avenue where the water takes. There's something else I also know. I also know where all the sewer goes from my neighbors. I also know there's smells, different smells. I know this, okay? So when you put something in there, like just happened, somebody passed something on to somebody that didn't look at it very, very carefully, okay? So what's going on down there right now, and he's not living in the house yet, right? He's got the house set up there. They stopped him from moving forward with the house. Okay, so what's happening, right? They had to block the ditch, the main ditch, to get the house across there to get it in there. So they blocked it, okay? So when they blocked it, that means the water comes across, goes in Miss Green's yard, come down to her septic tank, come down to my septic tank, right? I go to the state of North Carolina and tell them about it. They say, oh, Mr. Perkins, that's up to the town of Apex. We can't come out there and unblock that ditch. That's tied up in court, okay? Then I asked Mr. Robertson. He said, I'm not tied up in court. So somebody just told me a lie. You see what I'm saying? Okay, so what I want to know is that I asked, then I come to the town of Apex here. I said, look, I said, can somebody please come out and please unblock the ditch so that the water won't come down on our property? They said, oh, no. They said, we can't do that, Mr. Perkins. It's up to the landowner. He's got to unblock the ditch, okay? So I asked Mr. Robinson. Mr. Robinson, I can't touch it. You know what I mean? So somebody just done lied to us, the neighbors, all right? Now, the only two people in there that's having a problem right now is Mr. Robinson. Like I say, he's in his apartment somewhere. He's having a problem getting in. But me and Mrs. Green is having a problem stopping the water from going in our septic tank, right? Because we're not on city sewer. You know what I mean? And the town of Apex should be very, very careful how they put houses in areas like that that don't have city sewer. When you put them on a hill, right? God Almighty, He don't let this stuff go uphill. He'll let this stuff go downhill. So that stuff is coming down there on us, right? And I'd like for somebody to go back and tell the people to come out there tomorrow and tell me how to unblock that ditch so that water won't come down through her yard and come down through my yard and go down the state right away like it's supposed to be.
And Mr. Perkins, that's why we're here now, to discuss this item and get it moving.
If you would please tell them, the state, to come out there, I'll tell them exactly what to do. I've been there for 46 years. I know exactly where all the water's supposed to go.
Thank you, sir.
Unblock the ditch, let the water go, and that would free things up, okay?
Thank you, sir.
That would free things up, and then you will only have one other problem, all right? When he if you approve him for his house, okay, he can put gutters on there and some grass. That would stop one half of it, but he got one other problem. He gonna put that septic tank up on the hill, and you can't pump it up there. I don't care what they say, it ain't gonna work. That's gonna be another problem, you know what I mean, for them to think about.
Mr. Perkins, thank you.
That's all I got to say. Thank you very much.
Thank you.
Thank you.
So I'd like to address the septic issue. So I review all of the septic permits from Wake County before they're approved. And then before a building permit is issued, they're going to check, if it's not on town sewer, they're going to check that a septic permit has been issued for the property before they'll issue the building permit. So that will all be checked by Wake County first, and then in coordination with town staff. So until there's a septic permit issued by Wake County, he won't be able to get his building permit.
Wait, is that the house already there? What do you mean a building permit? The house is
Well,
already there.
the building permit has not been approved yet. It's still in process. He explained a little bit beforehand. There was his contractor and didn't quite follow all the rules.
Okay, all right.
And so that's all, but he's gotta get this rezoning done first before the town can approve a building permit.
Okay.
And then as far as the drainage concern, we can have staff contact stormwater staff, James Michiagno, or an appropriate other staff person, to have someone look at that ditch and what can be done. Because it's not the state, and someone at the town can look
It's
at
been
that.
6 months and we can't get nobody to come out there. Everybody playing a game with us, you know? And we pay our taxes just like everybody else in Wake County. Thank you very much.
So I have a question as it relates to the stormwater and septic. So this is not happening today, right? Like we're gonna make a recommendation and Mr. Robertson's gonna be a limbo for a bit longer and the neighbors are gonna have to deal with water a bit longer. And so while we are sitting in this space, I'm wondering if there is something that can be done, and I don't know if I'm looking to the town for recommendations, but I'm also looking at Mr. Robertson, if there's something can be done to help alleviate the challenges that the neighbors are currently facing until this is, the septic has to be approved and the permit has to be approved, not to mention just this rezoning has to be approved. And that's assuming that all that goes smoothly. So I'm wondering, while all of this is unfolding, whose responsibility, and can the town weigh in, and does Mr. Robertson weigh in at that point?
My understanding, he has a stop work order. He's not allowed to do anything on that property. He'll get in more trouble if he tries to do anything on the property. What we're gonna do is we're gonna talk with the town stormwater staff to see if there's anything that can be done, at least for the ditch, because that should be something the town could look into. In terms of the house and not having gutters on it and all that, I don't think that there's anything that can be done.
So when you said the stop work order, that's issued by the town, correct?
That's by the building inspections.
By the building inspections. And so if I understand Mr. Perkins, you have spoken with the town about the stormwater
All they
issue.
gotta do is come out there and I'll show them how to solve the problem, but they won't,
So-
they keep talking about they're tied up in court.
So I think my question is it sounds like Mr. Perkins' neighbors have come to the town before. So
Right,
can we
but
have?
I don't know who he talked to. It may have been in the building inspections department. I mean, it's, James Mistiano is the person that could help you. Have you talked to James, do you know?
No, I have not. Here's what the deal is. Nobody won't touch it. That's what they say. We can't touch it because it's tied up in court.
Mr. Perkins?
Mr. Robertson can't unblock the ditch.
Mr.
because
Perkins?
He'll get in trouble if he unblocks the
Mr.
ditch.
Perkins, the town staff is committed to getting the issue resolved as far as having stormwater addressed. So we're gonna walk through this process, and then we're gonna let town staff come out and take a site visit and do whatever they can to help the neighbors while this process is still going on.
Thank you so much.
Is that fair?
I appreciate that so
Thank you,
much.
sir.
Thank you, Chair. I actually have a follow-up question. I understand that the town is going to, ensure that the neighbors are talking with Mr. Perkins. The neighbors are talking to the correct people on staff. But I also want to understand, given the limbo that we're in, I want to understand what the town's ability is to mitigate where we are in this moment. I understand that the gutters, that's not gonna be the town, and that's, that's later, but we're in this limbo. What can the town actually do? I want the neighbors to understand what the expectation is, so when they walk out this door, that they understand where they're gonna be until we're out of this limbo.
Anything that's on, anything that's on private property, the town is not going to be doing anything with that. So, where the water's coming on private property across, going downhill, that is going to remain that way until all the approvals can be made with the rezoning, with the septic, with the building permit. And then once they're able to do work out there, they will not be able to get a certificate of occupancy and live in the home until the stormwater is taken care of, the drainage around the home. You have to have positive drainage away from the home, and typically they try to bring the swales on each side out to the street.
And that cannot be done until,
They have to get all these permits.
so can we give them, I don't have a concept right now of what the time frame is running. Can we give the neighbors an expectation? And again, I don't know if there is a mitigation effort that we can institute, because this is not ordinary. We recognize that. If there is a mitigation effort, we can institute temporarily. I'm sorry, that was a two-part question.
Yeah, we've already done all that. We were approved. Like I said, the only thing that held us back technically from the permit getting it was the setback, and everything else was approved, I was told. And that
We
was
don't
the-
have a copy, so we'll have to get with Wake County and make sure that all that was taken
That's
care of
the
properly.
estimate.
So I don't know how long the Wake County process is,
Well, Diane, question for you.
so I can't answer that question.
The purpose of this stop work order, was that because there was no building permit?
Yes.
Okay, so it's really, even if we rezone tonight, everything passes through, it's still gonna be
This is the first step
septic,
of a
then
many
building, and
step
then,
process,
okay.
yeah.
All right, well,
Just gotta move forward.
let's go.
So that was a two-part question. I'm sorry. I wanted to give the neighbors and thank you for that clarifying question. I want to give the neighbors a realistic expectation. And I understand that we don't know what Wake County's is, and maybe we can make some connections offline, so that they are aware of what the Wake County timeline is. But I would love for them to understand what the town of Apex's timeline is, so that.
This isn't what our department does. I don't know what the timing is for building permit review and issuance. Typically, houses that are being built from scratch take much longer nowadays than they used to. This is a renovation, so I just don't know how long it will take for them to do all those steps. Typically, I would say typically every step takes 2 to 3 months. I mean, it's taken that long for this, and it's not a fast process. So I think maybe by this time next year, it will all be finalized, but I can't promise before then. I'm sure he's gonna move as fast as he can.
This is the first step.
Can I just say one other thing? The problem is not on private property, the problem is on state property right now. It's in the state ditch. The state right of way, state ditch.
So the stormwater team will have to come out and address that.
Yeah, well, okay.
All right, so what we're gonna do is, we're gonna continue to move forward, so if we can,
Sharon, I'm so sorry, but I would just want to make sure it's clear. So it is not private property. You just gave an estimate for private property. Because it is in the right of way, thank you for that clarification. Does that change timelines at all? Does the town have the ability to?
We don't know what exactly is going on. I understand, you understand exactly what's going on out there, but the stormwater folks, to my knowledge, have never been out there to look at this. Amanda's literally writing an email to them right now to say, go out there as soon as you can and see what's going on. I can't promise it'll be rectified. I'm not sure. James is the most likely person to be able to help with this. I just don't know what it is that's wrong and if we can help. Sometimes it's as easy as cleaning out a pipe. Sometimes it's a lot more complicated than that. I really don't know.
Okay.
And I'm thinking maybe.
I can tell you when it's a stopped up ditch, they put gravel in to stop it up. All you gotta do. Take a shovel
Mr.
and
Perkins,
get gravel out.
Mr. Perkins, we'll get it addressed.
Okay, thank
We're
you.
gonna have the stormwater team come out to get it addressed.
We have, about 6 months ago, stormwater was added to our bill. But in front of my house is all over the circle where you have abundance of water that sits there, so it's not draining that problem.
Diane, you have the neighbors' contact information. Can you give them an expectation of when you will make those connections for them?
We only have mailing addresses, so it would be helpful if folks could give us their email address.
Or phone numbers?
Phone number.
Ms. Filligreeny, Ms. Stewart, Mr. Perkins, if you haven't already, please put your contact information on this sheet so we can make sure that the stormwater team gets back with you. Appreciate your patience. Ma'am, please come forward.
My name is Betty Anderson, and I've been in Iron Gate for 52 years. I was about the third family that built out there.
Hello, Ms. Anderson.
But I was confused. I have a drain in front of my door, and I called Apex, they come out and unstop this drain. And they told me that the county, y'all not responsible for the drains, it's for the county. The county did come out and get it stopped out. I'm confused, are we in the county or the city?
Lauren, do you know?
You know how long ago did the county come out and do that?
Since they was on us, the city, we got city water. So that was like a year or so. And I was confused because when I called Apex, they said that I'm confused. The street don't belong to Apex, but we pay Apex tax and city tax. And it belonged to the county. The county did come out and clean it out, though.
So the county doesn't have road maintenance crews, so it either was the town or.
No, ma'am, no, ma'am.
Well, I'm just saying, it's either the town or
Wake
the
County.
state. The state may have come out, but the county does not have road maintenance crews, so.
They said that the county was in charge of the drains, so I called the county and they did come and clean the drain out, thank God.
Thank you, Ms. Anderson.
So I have a question. Just want to backtrack and simplify the question to everyone who has attended. Aside from all the stormwater sewer issues, do you have any objections to how the house is placed currently?
We can't hear you. Can you speak up just a little? I do somewhat, because it's right in front of, it's right. But I guess it's something I can get used to, but as soon as they put it there, I said, I can't believe they just put the house on the street. But that's something I can get over. I do have a problem with it.
My question was, do you have a problem right now, the way it sits on the lot?
Yes, that's what I said.
Aside from all the stormwater septic issues?
To be clear, this is not the permanent foundation that the house is sitting on currently. Is that right, Lauren?
I don't have a problem.
No, we don't have a
You don't have, okay.
Not with that,
That's,
not with that, no.
yeah, aside from all the drainage, how it's currently placed right now.
And when
That's
we
okay.
had our neighborhood meeting, we made that known, and we made Mr. Robinson, we don't have a problem where it's sitting. It's just that the issues that are arising from not being able to complete what
The
needs to be done
construction.
to see if some of the, yes.
All right. Are there any other questions from the board? I'm going to close the public comment section. I think we've gotten a lot of feedback on this one, and we're definitely going to work with the town staff and stormwater management team to get out there and take a peek at things. Thank you. All right, so any further discussion from the members of the board, or do we have a possible motion?
I'll make a motion to approve.
I have a motion to approve from Keith.
I'll second.
And Ryan, Tim is going to second. All right, do we need to make any additional amendments or comments? And we've gotten it, we want stormwater team to come out and take a look. Is there anything additional we need to add to that?
Not that hasn't already been addressed.
All right. All in favor, say aye. Aye. Any opposing? All right. This will pass unanimously. Thank you, folks. We're going to move on then to new business. Amanda, you have a partial motion regarding various amendments to the UDO?
Okay, just a few amendments for you today. The first amendment is to add a use to the Unified Development Ordinance called Yard Waste Transfer Station. We are proposing that this use be allowed in the light industrial zoning district as by special use permit only. And the proposed definition is a permanent facility designed to store unprocessed yard waste material for transfer to off-site chipping, mulching, or landfill locations. We've proposed supplemental use standards similar to what we have for the existing use chipping and mulching operation, although this will not have that kind of equipment there. That it's be used for storage only. No chipping or mulching activities may occur unless that use is approved as a separate special use permit. And the standards would be storage is limited to 45 days and the pile height no more than 15 feet. The storage area shall be effectively screened from view so that it cannot be seen from rights of way or adjacent residential zoning districts. And outdoor material storage piles shall be set back a minimum of 25 feet from any property line or 50 feet from any property line abutting a residential district. And an access road for collection vehicles shall be provided to the entrance of the facility, which does not include residential streets. And then we're also proposing that this be classified as a Class 6 land use, which is the most intense land use type for buffer purposes, and that no parking be required for this use. Are there any questions for this UDO amendment?
I had a minor question.
Sure.
I'm curious as to the reason for effectively screened, and why not a buffer definition?
So the Class 6 land use provides the buffer standard. So depending upon what the adjacent land use is, but in addition to that, we still want to ensure that it's screened from view.
Thank you.
Okay. The second amendment is to update the date of our LiDAR data for topographic information in the UDO and to ensure that it's consistent throughout the UDO. There are 3 references to this data. It's currently the last date that we received it of 2013. We received new data this year, but instead of giving the specific year, we would just like to say the latest data that we have on file and indicate that that can be acquired from the town of Apex, as we should have all of the data for anything in our jurisdiction with no need for people to go to the town of Cary or Wake County for that information. So that's item number 2. Any questions for that item? Okay. And before I get into this last amendment on signs, I did want to let you know that in the coming months, we will be seeing some comprehensive updates for our sign ordinance in light of Supreme Court cases that have been issued back a few years ago, but then most recently that have provided some clarification on content-related standards and also related to a court case that went through the state system. So we're working on those to make sure that we're in full compliance with those decisions. The proposed amendments today should have no issues based upon those recent decisions. So there's about 3 things that are going on with these amendments here. So the first amendment that I'll talk to is the creation of an interior sign type. So we've all been to stores that now have the signs that say drive up, pickup location, and it kind of directs you to where to go to park to wait for your items to be brought to your car. We don't really have a sign type for that, and we have some signs that have been put up without a permit, as it's not been clear how that would be allowed. But we have some people that have applied for it, so I'm like, okay, this is something that's here to stay. This is a business model that's not going away, so we proposed standards for that. So we're proposing that that be allowed in the commercial districts. And the definition would be a ground sign located adjacent to parking spaces that are reserved as drive-up pickup locations and which meet the conditions below. So they would be allowed to be taller the further they are away from a public road. So no more than 10 feet in height and 10 square feet in area if located at least 200 feet from a public right-of-way or that's not visible from a public right-of-way. And such sign shall be no more than 4 feet in height or 4 feet and 4 square feet in area if located less than 200 feet from a public right-of-way or visible from a public right-of-way. And then the last 2 standards are typical of all of our sign types, referring to the sign illumination, design and color, and master sign plan requirements. So I'm going to pause there. Any questions on that part of this amendment?
I'm that frequenter of all the pickups, so I've seen all the signs and all the changes and all the signs. Wondering if we have any sort of concept, so I don't know if any of these folks have applied for a permit or not, so wondering if we have any concept on how this will affect the current signage that's out there, and if it needs to be a parking space. Some folks have you pull up alongside the building. It's not a designated space. So I'm wondering if there's flexibility. So first question is, how does it affect current businesses who have already installed signs? Do we have an idea of how they're going to be affected? And 2, does it need to be a parking space or can it be alongside the building?
So for businesses that already have signs installed, if their sign meets the proposed standards, then they will be in compliance. If they don't meet the proposed standards and someone complains about it, then we would have to go through an enforcement action on to bring them in compliance.
Do we have any sense, any sort of general survey of what the signs look like?
We have, but have we measured the height? No, so I don't really want to speak in this format as to what I think may or may not comply.
Okay, I will have to say I'm concerned about that, right? Like I'm concerned that that folks have put up signs, and I obviously would love for there to be some sort of standard, but I'd really hate for businesses to fall out of compliance by no fault of their own because we as a town did not have a parameter. So I'm a little concerned about that and wondering if there's any room for grandfathering or discussions, please.
So Amanda doesn't do zoning compliance, so I would say that anything that's out there is grandfathered by the fact that they weren't required to get a permit to begin with.
Okay.
It's when they come back and ask us to change something, we would not allow them to keep what they have if they want to get approval for something new.
Okay, thank you.
Even a complaint, as long as it's documented that they've had those, which we can look at. We look at Google Street View all the time to see what was there when, and so we're not going to be going and taking out any. It's if they come to us and say, we want to change this, and we're like, yeah, you can change that, but you have signs that are out of compliance, you need to bring them into compliance. It's only if they come to us for a new permit. So
What sort of,
it's typically things like other signs.
Or they want to change the
putting in a
design.
gas station at their grocery store. That
it wouldn't be like installing new lights.
they don't do that. That's They typically do not install new lights. They just switch out the bulbs, which we don't get into.
Yeah.
Okay, thank you. That answers my question. Thank you.
Yep. Okay. Any other questions on the interior sign type? Okay. So the next set of amendments is to clarify standards for internally illuminated signs, which currently there's not a clear guidance in the UDO. The prohibited sign section says that individually illuminated letters are acceptable, and so we're proposing to change that to individually illuminated letters and logos are permitted, and then set the specific standards in the sign illumination section to state that internally illuminated signs shall have individually illuminated letters and logos. Such letters shall have opaque sides, and the acrylic front shall be flush with the sides instead of held by a lip. This is getting how they're designed, so it's more attractive. And so, for an example, this is an old box style sign that we don't allow now, would not be allowed. Those were all have the light shining through the white. Is not allowed. Currently, only the individual letters are allowed to be illuminated. The proposal would allow the logo to be illuminated, but still, for the example, this section would not be allowed to be illuminated as it's currently designed, because it's designed to have if it's lit, I don't know that this one is, if it's lit, the white would be lit, the background, instead of the letters. And so what we're trying to avoid is the glaring, too much excessive light coming from signage. So this is just an additional example of signs that where the logo could be illuminated, but showing the intent of what an internally illuminated individual letters.
And this again would be, Apex Medical would be grandfathered unless they, as you use them, and Yamato, if you use them as the examples.
In that case, we've had this standard, so that might be a slightly different. If they were going to change out their sign and make a change to their sign, then we would ensure that it complies with the standard.
Okay, thank you.
And then finally, the last change is to the sign standards for planned development districts, which includes planned unit development, traditional neighborhood development, and major employment center zoning districts. Currently, they fall into the same sign standards as the central business district, the small town character overlay, which has very restrictive sign standards. And so we're proposing that instead the planned development districts follow the same sign standards as everywhere else in town outside of our downtown core. And then just making some cleanup in the table that has needed to occur over the years. So that's the end of that amendment. I'm happy to answer any questions that you may have.
Any questions for Amanda? Thank you, Amanda. Bring it back to the board for discussion and possible motion.
I make a motion to approve the UDO amendments as proposed.
A second.
All right, a motion from Ms. Sherman and a second from Ms. O. All in favor, say aye.
Aye.
Any opposition? Passes unanimously. Thank you. I have one more motion that we need to make, and that is to wrap up for the day.
Motion to adjourn.
Motion to adjourn. Thank you, Tim.
Second.
And Tina, Sarah, second.